You guys can see the folder that I have up. I'm going to open up a document here. I'm going to open up this Declaration of Trust. Does everybody see this? And then I'll just go and we'll just jump right in and we'll get a good hour worth of really core content. Let me just hit here. And questions. Yes, 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 yes. All right, great. Without further hesitation, let's jump right in. The first step, and I'm just gonna pre-frame and say this process that I learned is the result of years of study and research from mentors and individuals that shared the material. And the individuals that use this process, now there's many different theories out there. You've got a lot of theory that's floating around out there, people that come up with new ideas, you know, Boris and the Usufruct, David Clarence and the Executor, you know, all these people popping up, coming up with their new theory that's been around for 1 or 2 or 3 years. This process has been around for about a decade. It's been adjusted, it's been amended. We like, in the status correction course, we go over week by week, you know, everything having to do with status, okay? Including getting an international driver's permit where you do not need a driver's license and you just show it's an internationally recognized driver's, quote, permit. It's not a contract. It's not an adhesion contract with the United States or a franchise, a subsidiary like the state of California, the state of New York, etc. But we've gotten them. We have them. Passports of non-14th Amendment citizenship issued from the Department of State. And this is not you printing your own passport. This is not you printing your own license plates from your computer. This is from the Department of State issuing you a passport saying you're an American national, not a U.S. citizen, property, 14th Amendment slave. Okay, so we're able to get things like that. We can, on the status correction class, we will show you those redacted paper with the people's, you know, names and private information, you know, blanked out. We're putting those together. Okay, so this stuff works as far as getting recognized identification that you are a private living man or woman, or you're a private non-corporate employee of the federal corporation, be that Australia, UK, America, you know, wherever you're talking about. People have won court cases of every kind. People have gotten paid 6- and 7-figure million-dollar common law tort claim processes after getting their status corrected, specifically using this process. So that's why this process, or this plethora of processes, has been selected to be kind of the focus point of this webinar and the status correction course. Okay, so it's not theory. It's based on results. You know, when you've seen people that have been, you know, imprisoned for, you know, 2 days or 10 days or 10 years sue the United States government for wrongful imprisonment and actually win millions of dollars, and when you actually seen the United States Treasury checks that have been sent in a payout as a settlement to settle the common law claim against the prosecutors, against the United States of America as a corporation, etc. When you've actually seen that stuff, your level of knowledge and belief that this is the right process, you know, goes through the roof. Okay, and when you deal with contractors who regularly do that every season, you know, maybe every month, and actually get people paid money or dismiss their criminal charges, or other remedies like that, when you actually see that regularly, it brings a whole nother level. So that's where I'm talking to you from a point of understanding and experience. You know, you want more information, you want to see more proof, you want to see more, you know, success cases and things like that. We welcome you to join our status correction course, or to call the number on the website, the 505-340-3632 number at any time, and you can chat it up with Jay. He'll give you a free consultation if you call and you say, you know, I just have some questions and so on and so forth. Just call us. We're available. We're a phone call away. We're an email away. Start a conversation with us, and you know, whatever you need to hear, whatever you need to see, maybe we can provide it, maybe we can't. But we're just going to be sincere and honest about what we can do, what we're still working on. Okay, but this is the forefront of where a status correction, a secured party credit remedy process would start. The bottom line is, and we've got an article on the website. If you scroll down to the second to the third, again, this is all the stuff that's covered in the status correction course, itemized here in this post here. You've got this, right here. So we're going to go over some of the initial material, but this is the entire list. So anything that's not on here may not be covered. So just ask if you are specifically looking to learn something specific. This is another overview video we did. It's an hour and 50 minutes explaining the whole status correction process. It's a big overview. We're only going to go over one of the steps, which is setting up the initial trust, which is the precursor to the UCC recording process. If you scroll down, here you go. Did you know that your legal name, John Henry Doe, is a constructive trust? Okay, you must read this if you want to understand the documents that I'm going to show you. Okay, the legal name, John Henry Doe, or whatever your capital letters name says on your birth certificate, on your driver's license, it's a trust. Okay. If you don't understand what a trust is, you got to go and research what a trust is. We have lots of videos on our YouTube channel, youtube.com/wincontractlaw. We have a video called Public Trust, Private Trust Explained. Watch that video. You've got Weiss's Concise Trustee Handbook. You've got a lot of free material out there about trust. A trust is basically a grantor or the creator of the trust, also known as the settlor, via creating a contract with the trustee. Now, how do you form a contract? It has to be an exchange of something of value as well. Okay, just like in a marriage, you exchange wedding vows and wedding rings, and that solidifies and cements the contract. Okay, it's a little bit more powerful, or it's a lot more powerful than just signing a piece of paper saying I promise to do whatever. You have to give something of value. That ring is what is the property or the res, okay, in a trust that actually grants the state control over your marriage, control over your financial affairs, your tax affairs. It's basically a corporate merger between the two trusts. So John Henry Doe and Jane Henry Doe get married, and they form, if they get married by the state, they are giving the state a interest in the products, the tax implications and liability, in a sense, the finances are conjoined together. Any disputes must be adjudicated by that state. Okay, so that's the divorce proceedings. You would be subject to the opinions and rulings of a judge, which may be slanted and tipped for or against your favor. So do you want to contract and get some judge to be able to determine what would happen, how would the assets get split if you split? And also the offspring of your marriage is now property of the state. So that's what happens when you get, married. But the legal name, the John Henry Doe legal name, is a constructive trust. Why is it a constructive trust? Because there's two kinds of trust, constructive and express. Okay? So an express trust is this. This is a private express trust organization. Okay? As you can see, I will just start reading. This contract and declaration between the undersigned parties, known hereafter as the creator or grantor and the exchanger, agree to wit. Creator herein offers for consideration to create an organization under the common law having a fixed number of certificates which evidence a right of distribution commonly known as a pure trust organization or unincorporated business organization. And exchanger herein agrees to exchange in trade goods and valuable consideration for certificates of the newly created organization. Therefore, the parties mutually agree, promise, and covenant as follows. Consideration. Exchanger herein agrees to bargain, exchange, assign, convey, and deliver to this organization or its appointed trustee. Immediately upon the execution of this agreement, Creator agrees to appoint a trustee having authority to carry out the exchange and hold and administer the consideration received. The initial exchange, a description of the consideration, whether personal and or real property, and the number of certificates issued shall be documented in the minutes of the organization. How many of you who have trusts are actually documenting minutes of the trusts? How many of you are actually documenting bills of sale and issuing certificates to the exchangers or beneficiaries of the trust? And in our experience, not many people. Many people are just putting together this declaration of trust. Now, why am I going through this? Okay, you got the administration of trust estate, irrevocable agreement, appointing of the trustee, board of trustees, discretionary power, acceptance by the trustees, administrative provisions, yada, 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 all the way on 7 pages, and in witness, the term of years, the legal domicile, the common law, the purpose and intent of the agreement, signature between the parties, and witnesses, okay? So this is an express trust. A trust is a contract. It's a specific kind of contract in which there is one person's putting property into the hands of another for the benefit of yet another third party or parties. Those third parties are called the beneficiaries. Okay, so look at this graph here. Go online, find a little triangle between the 3 parties of the trust, grantor, trustee, beneficiary. But the bottom line is it's based on contract. It's based upon a meeting of the minds. It's based upon consent. The John Henry Doe legal name that was created with your birth certificate being stamped with, or the registration of live birth with your foot being placed on that, and the description or the metes and bounds of the description of the property, which is you, which is the res that was put into the trust, that is just like the marriage, where now you're contracting the state to be in control of this trust. Okay, so if that makes sense, I just want to see if you guys say yes or no, or if you have questions. Please, we're going to do questions only about what I ask about, because I'm trying to sequence this and have the most amount of people understand, you know, the main point of the webinar. If you have other questions, send us an email, set up a coaching call. You know, there's many other forums to ask off-topic questions, or maybe at the end of the presentation, I can spend another hour with you guys and ask, you know, non-direct questions. But let's see if you have any questions about what I'm talking about. Do you guys understand that the John Henry Doe Trust, your name, your legal name, is a trust? It's not you. It's not a corporation. It's a trust. The kind of trust that can either be express or constructive. Express is like this, where all the meeting of the minds is documented on paper and expressed, signed and witnessed by the parties. That's an express trust. A constructive trust is, well, they just took the property or the res, they gave it from one party to another, and there's no clear, you know, it's not clearly spelling out for you that it is a trust. But you have to, like, use your common sense to determine that it's a trust. You have to figure out that it's a trust. Okay, so do you guys understand that, or is that over some of your heads? Let's see, 87 questions. I understand the trust. Okay, yes, I got it. And the child is born and trust. And by the way, you guys can raise your hand and I can unmute you, but it's going to have to be quick because we're trying to just get through a lot of material here. At the end, we can chit-chat. I'll stay up as late as you guys want. Access in the trust. What does that mean? State is the trustee. Got it, got it. Is that like a domestic trust, as it says in the IRS website? Sounds like you have to go soon. Da, da, da. Why don't you believe A for V? Why do you pay federal income tax? Okay, these are questions for the end. We're just going to go on topic. Those are from a little while ago, but okay, yes, understand. Does anybody want to raise your question? Because I don't want to leave people behind. And when you get this, you'll understand how powerful that this is. And we can go through all the 15 documents, you know, a little bit quicker. But, you know, the foundation is always what you need to spend the most amount of time on. So can the trustee give a birth certificate to put in trust? A certificate is something that's issued because the legal title is being held elsewhere. Okay, so you can't put a certificate. If you put a certificate into a trust, it doesn't mean that the trust has a legal title. It just means that the trust has equitable title. Does anyone have a question about what I just said? What if I have authenticated the birth certificate? It doesn't change the fact that the legal title is still not held by you. Can I explain it some more? Okay, what do you want me to explain it some more? It's second nature to me, so I don't know. You guys got to really like, for the asking of the right questions is for the giving of the right answer, as we say. You're not the holder in due course. You just have a certificate, okay? The legal title is still in control of the government. They have something else. They have that registration, okay? So you haven't collapsed the trust but just by getting an authenticated copy of your birth certificate. All you're doing is authenticating that that's an original, true, and correct birth certificate. So what? It's just a certificate. It's just like having an authenticated apostilled certificate of title for your car. It doesn't mean that you can take the tags off and the license plates off. You're still going to get pulled over and harassed by cops. Does that make sense? Yeah, split title. You got to look up split title. A trust splits the title. When the, let me try to zoom in a little bit to this. Okay, so when the grantor gives a exchange to the trustee maintains legal title, and the beneficiaries are issued a certificate, and the certificate holders have equitable title. Okay, and that's why you can use your car, you can sell it to someone else and sell the certificate and the ownership and interest to someone else, or a corporation or another person, any legal entity, an individual or a corporation or a trust. You can sell it to someone else. You could paint it whatever color you want. You could, get whatever boombox, system. You can get whatever type of rims you want on it. If you want to flare out your car, if you're one of those guys that do that, and really into your car and doing all that stuff, you could do whatever you want to your car. You could clean it, you could vacuum it, you could throw McDonald's wrappers on the floor. You could do whatever you want. Okay, you can have anyone that you want as a guest driving shoddy in the car, or driving in the back, or sitting there as a guest in the back of the car. You can do whatever you want with it. Okay, that's equitable title. Okay, but you don't have legal title. Legal title is control. They set the rules and regulations, and they can fine you and seize the property if you violate their rules and regulations. Okay, so how is that any different if you have a certificate of live birth that's authenticated and apostilled? All that's saying is this is a true, authentic certificate. I have equitable title. Okay, doesn't mean you have legal title. Okay, the process we're going to go over is a process that helps you to take control and maintain legal title. Okay, but in order to maintain legal title, you need to give equitable title to someone else, because you can't have legal title and equitable title and have it still be a trust. Okay, you need to select, in this process, you need to select other beneficiaries and give them certificates of interest that makes them the owners of John Henry Doe. That makes them the owners of the trust, John Henry Doe. And when you do that, and you got your proof of mailing and they've accepted it, if they signed a document and sent it back to you, we just put on the website. We just gave you that document right here on our website. Posted January 26th, notice to beneficiaries of a trust. This is what you would send to your beneficiaries, have them sign the bottom letter, but they don't have to sign the bottom letter. I'm going to read this to you. It says, let me just pull this up a little closer here. All right, notice to beneficiaries of John Henry Doe Trust. Dear Bob Joseph Doe, this notice is to inform you that John Henry Doe, the living man, see how it's punctuated with the colons and the hyphen and the colon, that means John Henry of the family Doe, the living man or woman, flesh and blood, has executed an irrevocable express trust on so-and-so date, to be handwritten in there, naming you as a beneficiary. The trustees of the trust are: first trustee, John Henry Doe, information; second trustee, Mark Dennis Awesome. Mark Dennis of the family Awesome. He's awesome because he's the second trustee. As you will learn as we go through this, the second trustee is the most important part, or the most important individual that you need to enroll to be a part of your trust. Okay, you need to have two trustees. Otherwise, you being the only trustee, there's a term called in persona conjuncta. I'm going to type it in here again. In persona conjuncta. Look it up. It means that you are the trust. You don't want to be the trust. You just want to be a trustee of the trust that has a hold harmless agreement that you'll have no liability operating as trustee of the trust. And you've got that recorded on public record with your UCC1 recording, and we'll get into that a little bit later. And you have a security agreement that covers a lot of bases to reduce your liability and set the terms and conditions and so on and so forth, okay? And yes, it places a lien on the property and assets of the trust, first in time, first in line, so on and so forth. Yes, Yolanda says, I compare to being stockholders. The beneficiaries are compared like in a corporation. They would be like the stockholders, only this is a trust, so we call them the beneficiaries, not the shareholders. And they're getting certificates of interest, just like how in a corporation you would, here's a sample, okay, and we're in the process of creating a variety of different kinds of fancy colored borders. You can have it vertical, you can have it be, you know, lengthwise horizontal. You know, there's no you know, a lot of membership certificates and interest certificates for corporations or LLCs or whatever. You know, a lot of them are actually like, you know, a little bit, you know, they, in other words, you can design it any way that you want. It doesn't have to be this document. It doesn't need to be a blue border around it. And we're going to design a few pretty templates. We have some good graphic, you know, designers that we solicit to, you know, help make this a little fun, give people a little bit of options and personalization to their processes. Okay, so but this language and stuff is right out, like a lot of it is right out of Weiss's Trustee Handbook. A lot of it is right out of The Art of Passing the Buck. The language in here has stood the test of time. You can switch, you know, the numbers around a little bit. You can, if words have the same meaning, you can switch it around if you're really comfortable with it. But if you're pretty new to this, I wouldn't switch the language around. So, you know, we have where you can get the language here. And we did post something on YouTube about certificates of interest as well that you can check out there as well. On the, I'll type the link into the chat bar in case you guys trying to. Okay, I can't type anything to the chat bar. Yeah, we're going to see what we can do with a replay. Just try to stay on the webinar if you can, because it's possible some of the material we might hit a max recording and the stuff at the end might not get recorded. How will this benefit me in court case? Okay, like I said, we want to teach the material and go through specifically the understanding of the documents on the screen and the concept and the process. We can ask specific questions like, how does this relate? How can this help with that? You know, mostly at the end, and I will stay up as late as you guys want to stay up to answer all those questions at the end. This will benefit you in a court case. And if you were jail and prison, if you were in jail or prison, you can win millions of dollars in a common law tort claim. Make sure you check the material out on the website about the common law tort claim under the product section. But you need to do this process first. This is the first underlying step. Okay, because you don't have common law. Again, the government has the legal title to that constructive trust, and unless the idea and what we're doing here is we're converting the constructive trust into a express trust, appointing the parties, having the proper documentation and meeting of the minds that document so that you can prove and show, and you can even include a lot of these on your UCC1 to show that the trust did have a meeting, there was a bill of sale, there were witnesses, there are beneficiaries, you got your certified mail that you sent, the certificate unit, which is this, right? And this is unsigned version, obviously. But it says, pursuant to the contract dated so-and-so, creating the above said pure trust organization and in compliance with all terms and conditions contained thereof, Dylan Smith, that's who this trust named as a beneficiary, holds 25% of Mark John Smith Trust, copyright, trust certificate units subject to the following provisions, terms, and conditions. The holder shall be entitled to a proportionate share of all distributions declared and made by the trustees in the ordinary course of business or upon liquidation of the trust organization. All units are fully paid and non-accessible when issued, and no liability for the actions of the trust or trustees shall inure to the holder. The holder shall have no rights, powers, or privileges or interests or in or control over the assets or management of this trust organization. The holder can only transfer these units in compliance with the restrictions, terms, and conditions set forth in the Declaration of Trust. A transfer must be expressly endorsed and provided below. Now, so who's setting all these terms? You know, the legal title holder. It's just like the DMV saying, you got to drive the speed limit, you got to get your thing inspected every couple of years, right? We're issuing a certificate, but we're telling the certificate holder what the terms and conditions are, okay? The certificate is signed and dated. It becomes null and void, no force or effect at the death of the lawful holder of record. Deed of transfer. So yeah, I mean, the certificate holder is a holder in due course of this certificate, but it doesn't mean that they have a legal interest in the trust whatsoever. And if you read this notice to and so there's a witness, exchanger, so on and so forth. I want to read the notice because this kind of puts in perspective of what you're doing here. You do not. Okay, so here the trustee of the trust and says you do not have to do anything to accept this position. I mean, excuse me. This is a letter. Let me backtrack. This is a letter to the beneficiary. Okay, you can have one or more beneficiaries. It says this is a notice to inform you that Mark Johns of the family Smith has executed an express. What do we want to put in there? A irrevocable express trust on so-and-so date, naming you as beneficiary. The trustees of the trust are Mark John Smith at this address and Susie Smith at this address. You do not have to do anything to accept this position. Please see the enclosed certificate unit 001. And that would be this, or whatever number, whatever unique identifying number you want to put on it. I don't know if this one has a unique identifying number on it, so you may want to add that. I actually don't see one on here. So that is something that needs to be added. You should keep this certificate in a safe place, as this is proof of your interest in the trust. Again, if you're issued a certificate of title for your car, you're going to keep it in a safe place, are you not, to prove your equitable interest. By accepting the TCUs and this notice, you agree to be bound by the terms of this notice. Number one, the exclusive venue and jurisdiction governing law for Mark John Smith Trust is American common law, with no regard to laws governing conflict of laws. What that means is if there's any conflict about what law governs, because the beneficiary is in the United States and the trust is in the common law, there's no regard to any laws that govern the conflict of laws, meaning it's going to be governed exclusively by the American common law, okay, or whatever law form that you want to choose to put in here, private, international, commercial law, whatever, okay. The exclusive form of adjudication for any and all claims through Mark John Smith Trust is Best Guy Trust Protector Services, Inc. That's just a random trust protector company that I made up as the exclusive adjudicator as identified in the Declaration of Trust. So again, we're not just making this stuff up. It's all governed by the Declaration of Trust or the trust indenture, okay? So in other words, if the beneficiary wants to, has a dispute, a claim, believes they have a claim, some dispute over their position in the trust, they believe that they're entitled to more money that the trust is supposed to give to them, they could raise claims and disputes, but it's going to have to be governed under American common law, and it's going to have to go, the exclusive form of adjudication is going to have to go through Best Guy Trust Protector Services, Inc. Okay? You can pick an individual, a friend that you trust. You can pick you can pick understand contract law if you want us to be your trust protector for your trust. This is usually not going to really ever be an issue because you're selecting who your beneficiaries are. So you're going to select family members like your children or your kids, or someone who's not going to become a hostile beneficiary and try to sue you to collect the money that's in the trust, because they're not necessarily entitled to the money that's in the trust. They might be entitled to some beneficial positions and maybe some distributions, but we'll get to that in the rest of this letter. Okay. So whatever the trust protector is, it could be an individual, a company, a trust, whatever, acting as the exclusive adjudicator as identified in the Declaration of Trust. You hereby waive the right to use any statutory public court or venue for raising or settling any claims or disputes arising from your acceptance of this beneficial position, unless agreed to by both trustees in writing. So that means if you choose to bring this into a statutory public court because you feel it will help you in your favor, then the two trustees can change that clause in writing. You agree that breach of this clause by opening any lawsuit against the trust or trustees shall constitute a fine of $500,000. for each instance, plus any other actual damages. And here we go. Here's the bottom line. You may waive your beneficial position in the trust at any time by providing written notice to either of the two trustees listed above. The trustee cannot make distribution to you until you return a signed copy of this letter, which is down below here. I, Dylan Smith, have read the above letter and accept the distribution terms of the trust presented here. Signature date. Okay, but you notice at the top it says you do not have to do anything to accept this position. Their acceptance of the money, the certificate, right, is the consideration. You guys have all heard contract law. If you send an instrument and the other person keeps it, is there a contract, right? Haven't they accepted that? I'm sure you guys have learned that through, you know, Creditors in Commerce, Winston Trout audios, some of our material, our YouTube stuff. If you send them the money and they keep it, right? So you might want to have your third-party witness mail it, certify affidavit of what was put into the envelope. You might want to have your certificate, your certified or registered mail, proof of signature, green card receipt. You might want to even put on that green return receipt, Dylan Smith, beneficiary of Mark John Smith Trust. Now they sign for that. They're signing in that capacity, and you're getting that green card returned with their signature on it with the stamp of the post office showing that it has been delivered, and you've got a contract, and you can scan that green card receipt into the back of your UCC-1 as an attachment to show that you've put together this trust and that you have appointed other people beneficiaries or other corporations or other persons as beneficiaries, and they have accepted that. Now you've got indisputable, irrefutable truth that you have waived your beneficial position. So later on when you do the process notification of record where you send to the Secretary of State letting them know that you are no longer the beneficiary, the government is no longer the trustee of John Henry Doe, you've taken control, you've taken legal title. This is one of the notices that you sent, okay? And you're sending it to two Secretary of States, the IRS, and what is the other one? Department of the Treasury, okay, to update your status. Okay, those are the main places to send it to. You don't need to go overboard and send it to, you know, there was one guru that was like, oh, you're going to send it to all 20 different government agencies all over, attorney generals and this and that. You're just going to raise a lot of unnecessary red flags for you. We're just going to show you the ones that it's necessary from our point of view. Okay.